Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
So it is a very short question in this appeal, whether the petitioners will be treated as an employee under the Gratuity Act, my lord.
Under the
Gratuity Act, under the Payment of Gratuity Act 1972, my lord.
Payment of Gratuity Act?
Yes, my lord. The petitioner's claim is that he is entitled to gratuity as he has been serving under the McOffet. The legislature has held that they are on the separate footing, therefore they will not be treated as an employee or regular employee.
They are on contract?
Not contract, my lord. Actually, the government has come up with a scheme known as agro-custom hiring scheme under border area development for mechanized farming, my lord. So that scheme continued for about 20 years. After 20 years, it was abandoned. Government could not continue with it. So the petitioner have been working there for about 20 years, and now after that they say you are not a regular employee of the McOffet, and under the Gratuity Act you are not entitled to get any payment. That was the finding of the legislature as well.
Let us see. Where is your letter of appointment?
This was appointed by the managing director of the McOffet.
Which page? 179.
Page 179 is the appointment letter.
This is the probation.
Yes.
After that, where is the formal appointment?
Well, this continued only. Thereafter there was no appointment further.
There was no confirmation.
No, man. Because finally this scheme was abandoned, and a decision was taken somewhere in 90s that this scheme will not continue. And in 2001 it was abandoned.
What are the previous orders?
My London single judge. It's 209, my lord. The last part is paragraph 10. The case of petitions therefore is squarely covered by the above noted judgment, and as such after receipt of the order.
Where are you seeing?
Page number 2009. Sorry, 2000. Start from 2007, my lord. Sorry. Start from 2007.
2000?
207, my lord.
203, Your Lordship, Annexion 9 to David Memo of Appeal.
Where is the imperial judgment?
This is the imperial judgment, my lord. This is the imperial judgment at page 20, starting from 203, my lord. And the operative part is paragraph 8, my lord. 20, page number 207.
14th March? No,
21st September 23.
Who is the respondent number 3? The Federation?
Number 4 is the petition.
Respondent number 3 is?
Statement.
Come to paragraph 2 of the order. It says,
Border area.
employees of the respondent number 3. Who's the respondent number 3?
Border Area Development Department.
Border Area Development?
Department, yes. Government of Meghalaya. Government of Meghalaya, Border Area Development. Actually, it should have been, my lord, number 4, because we are the employees under the MACOFET, which is number 4. Number 4. Yes.
It's only gone by the Guwahati judgment.
Yes, madam. He's relied on the judgment of court.
So that you're covered by the same. Why do you say that you're entitled to gratuity?
Madam, this-
What are the other judgments?
The Supreme Court has really said, my lord. So far, my lord, there are two parts here. MACOFET as a whole, their judgment of this honorable court.
Sorry?
MACOFET is liable to pay gratuity to its employees. This judgment has already been passed by this honorable court by single bench as well as by division bench. And even before the Supreme Court, this MACOFET has.
Yes, but you people
That you think
you
of,
had
yes.
accepted in 2002.
They were also on the same line. They also accepted the same position with the golden
Show
handshake.
us. Show us.
Page 67.
Please come to page 67. There is a judgment passed by the single bench.
No. You come to page 49.
40.
These are regular employees.
Yes, my lord.
You are not.
Yes, that is the learned single bench has come to that finding that we are not the regular word. What regular has come there, my lord.
It's not something that I can either it is. The appeal is to be heard. Paragraph. According to the appellants, the writ court merely relied on a previous order of the Guwahati High Court pertaining to similarly placed persons as the appellants, full stop. The writ court also observed that despite the appellant's severance from service in about 2001, the writ petition had been carried only in the year 2022, full stop. However, according to the appellants, in at least two judgments during the interregnum, it has been held that notwithstanding a golden handshake being offered, erstwhile employees of the Meghalaya
Cooperative Marketing and Consumer Federation.
Cooperative Marketing
and Consumer Federation Limited.
and
Consumer and Federation
Marketing and Consumer Federation
Limited. Yes.
Limited, just check the thing, would also be entitled to gratuity. Full stop. Paragraph. Since it is a pure question of law and the basic facts are already there in the pleadings filed before the writ court, The appeal will be heard on the papers now produced. Full stop. The appeal will appear for hearing 3 weeks hence. Give a date.
Your Lordship, only notice will go to the respondent number 4, Your Lordship.
We have already served.
Your for?
I'm appearing for respondent number 1, 2, and 3, Your Lordship.
Very well. Paragraph, since the fourth respondent is not represented, despite the appellants claiming to have served such respondent, such non-appearing respondent should be served afresh and also forwarded a copy of this order, full stop. An affidavit of service in such regard should be filed.
Apply.
Item number 2.
My lord, in this case, 26 days delay is there for preparing appeal.
Yes, what is the matter about?
The matter relates to appointment of the social officer in the
Appointment
Meghalaya,
of a
social officer in the Meghalaya Institute of Mental Health, Government of Meghalaya. 26 days delay. And the respondent number 5.
Right, let us see what the matter is about. Social officer,
Madam, social officer.
admin.
Madam, and in hands. So at this stage, Chief Lordship, please, we should notice to the
No, no,
private
finish it
respondent.
off. These matters have nothing, no merit.
My lord, may come to the advertisement, my lord.
Just a second. There was an examination.
Examination was there, written test, interview also there, and subsequently the petitioner came to know through RTI the private respondent did not have the essential qualification. Madam. That is the case. So my prayer is to fall, my lord. If my contention is not persuasive to my lord, to set aside, I pray for ordinary prayer. Allow me to file afresh or remand by the writ petition. Allow me to amend my writ petition and challenge the advertisement. That is one of the ground taken by the learned single bench.
No ground, no merit in your petition, sir.
My lord, I have with you, I have no ground.
First and foremost,
Yes.
you challenge the
Recommendation.
conditions.
Yes.
Forget recommendations. You challenge the conditions first. You can challenge the conditions before submitting to the conditions.
But-
Once you submit to the conditions, take a chance,
But-
you cannot challenge the same.
But that is, I bow down with that. But only,
So that part of your challenge becomes irrelevant.
but
Next is, you say that you are the better candidate between number 5 and you. Now, over there, so the word preferably has been incorporated by the Public Service Commission, despite noticing that the requiring department did not use preferably and only the PSC put preferably, you participated. So your challenge to preferably goes. Now, once challenge to preferably goes, there is a rule, ceteris paribus, which is other things being equal, preference will be given to someone who has more than that. Other things were not equal in this case. The other candidate also met the eligibility criteria and scored higher than you in the selection process. So, the preferably would not apply. It's therefore, and there's an element of, discretion that a selection committee has, unless it appears to have been exercised in a completely perverse manner, that an ineligible candidate has been taken and exemplary candidate has been left out. The court does not interfere in these processes.
my lord, I may allow to show only 2-3 annexures on the, where
Yes.
it is very clear that the selection authority, appointing authority has communicated to the selection authority the criteria. And the MPSC has divided from there.
No. You are not entitled to take that point.
My lord,
You participated in the process. If you had challenged it before the process, yes. After having taken a chance and participated, you are stopped from challenging that.
my lord, my case is simple case with due profound respect. My case is that I was not aware, not only me, other candidates are not aware. Only after selection was over, we came to know this.
No.
And it is a clear-cut deviation, my lord.
No, not acceptable.
Only,
Not acceptable. You should have been aware.
my lord, that through RBI it came to light only. That is a grievance only.
No.
Otherwise, my lord, lordship is correct. I have no right. Once a person can take the chance to participate, I have no more rights. But my case is peculiar that they are not aware.
No.
Through RBI
Should
only.
have been aware.
Only if lordship allow me to file amend the writ petition and challenge that replacement.
Nothing, not at all. Certainly not. That you're precluded from doing that. We can't give you that right. The delay of about 26 days in preferring the appeal is condoned in view of the good ground shown. Paragraph. The appellant, who aspired to be appointed to the post of social officer in the Meghalaya Institute of Mental Health and Neurological Sciences, bracket MIMANS, challenges an order of August 14, 2023, by which her petition under Article 226 of the Constitution to challenge to question the propriety of the respondent number 5 being appointed to such post has been repelled. Full stop. Paragraph. 2 principal grounds were canvassed by the appellant before the writ court. Full stop. The first substantial ground was that despite the requiring department setting down certain eligibility criteria for candidates to apply for the post, the Meghalaya Public Service Commission purported to tweak one of the key conditions, full stop, According to the appellant, the MPSC had no authority in such regard. Full stop. The the appellant further contends that the alteration effected by MPSC has to be disregarded and the selection process ought to have been conducted without adhering to such alterations. Full stop. Paragraph. The other ground canvassed is that the appellant was the better candidate in terms of the quality of the institution from which the appellant obtained her degree. Full stop. To boot, the appellant claims to be more experienced and having had a better claim to the post by virtue of her educational qualifications and experience. Full stop. Paragraph. It is necessary, at this stage to notice the extent of change brought about by the MPSC in the eligibility criteria suggested by the requiring department. Full stop. The Director of Health Services, (MI), by letter dated March 22, 2016, had indicated that applicants should have more than 5 years as a post-degree experience in the field of mental health from recognized institutions. Full stop. The MPSC modified this criterion by inserting the word preferably within quote therein. As a result of the change effected at the instance of the MPSC, the entire ethos of the qualification stood altered. Full stop. Paragraph. If the original condition, as suggested by the Director of Health Services, (MI), was allowed to remain, it would be obligatory on the part of a candidate to have more than 5 years as opposed to be experience in the field of medical health from recognized institutions. Full stop. Upon the criterion being modified, it was a qualification that would allow a candidate to be given preference, provided that other things were equal as between two candidates. Full stop. In other words, if two candidates were jointly at the top and one had to be considered for the post, the use of the word within quote preferably, close quote, implied that in such a scenario, if one of the candidates had the preferable qualification, such candidate would be selected ahead of the other. Full stop. Paragraph. On facts, the trial court found that the basic eligibility criteria had been met by the respondent number 5 to the writ petition, and comma, as such, comma, no grievance could be raised as to could be raised on such ground. Full stop. It is also an admitted position that the selection process was competitive and marks were awarded, and the respondent number 5 scored high marks than the appellant herein in the selection process. Full stop. In such circumstances, comma, when the candidatures of the respondent number 5 and the appellant were considered, comma, the respondent number 5 stood ahead by virtue of having secured higher marks in the selection process. Full stop. Paragraph. Even if it is considered that the preferable condition that the advertisement stipulated was complied with by the appellant and not complied with by the respondent number 5, comma, in the event both the candidates were similarly placed at the end of the selection process, comma, the preferred criterion would have tilted the balance in favor of the appellant herein. However, comma, that was not the case, full stop. The respondent number 5 had secured more marks in the selection process and, comma, as such, the two candidates not being similarly placed, comma, the preference condition could not come into play. Full stop. There does not appear to be any arbitrariness or any arbitrariness in the selection process or any error committed in such regard by the selection committee. Full stop. Paragraph. As to the substantial charge of NPSC not having the authority to change any conditions suggested by the requiring department, comma, the petitioner could not have urged such ground. Full stop. Such a ground could have been raised to the, not the petitioner appellant, prior to the appellant participating in the process. Full stop. Once a person participates in the process with eyes wide open and being aware of the terms and conditions thereof, comma, upon having taken a chance, comma, such person would not be entitled to question the process or the rules thereof. Full stop. Paragraph. Auspicious dash and completely unbelievable dash ground is raised by the appellant to the effect that the appellant was not aware of the modification of the condition prior to the appellant getting to know of the same pursuant to a query raised under the Right to Information Act 2006, I suppose, or 5. Full stop. Such ground cannot be countenanced. Full stop. There can be no doubt that the appellant, comma, like all other candidates for the post, comma, applied upon the final advertisement in such regard having been published. Full stop. Obviously, comma, the final advertisement contained the alteration as made by MPSC from the suggested conditions as recommended by the requiring department, full stop. In such a situation, comma, upon the appellant having taken a chance under the rules which were indicated in the advertisement, comma, the appellant is estopped from challenging the rules or the conditions indicated in the final advertisement. Full stop, paragraph. The writ court has referred to the facts and the applicable law, full stop. All relevant considerations were taken into account, full stop. As such, comma, the order impugned dated August 14, 2023 does not call for any interference. Paragraph accordingly, comma, whatever the WA number so and so is dismissed. The application is disposed of. Paragraph, there will, comma, however, comma, be no order as to cause.
Item number 3.
Yes. What is this about?
Look, this is the PIL concerning
That's
the
number
papers.
7.
My lords.
A further status report dated October 9, 2023 has been filed by the state in pursuance of the previous order of August 28, 2023. Paragraph, since it is evident that the departmental proceedings are continuing, comma, let the matter appear a further 3 months hence, in the hope that such departmental proceedings would have been concluded by then, full stop. The latest status report pertaining to the departmental proceedings should be filed on the adjourned date.
Yes. I'll be obliged.
Yes.
Item number 4.
Yes, sir.
Made to you, Lordship.
Yes.
Lordship, this is an appeal against the order passed by Income Tax Appellate Tribunal, Guwahati. We have received the affidavit filed by the respondent. But Lordship, I am seeking an accommodation on behalf of the Lord. Seeking an accommodation, Lordship, on behalf of the Standing Council for Income Tax.
You're for the appellant?
I am from the appellant.
Very well. And there is also delay.
There is a delay, Lordship.
Very well. Since the applicant seeks an accommodation, comma, let the matter appear a fortnight hence.
I'll apply, Lordship.
Item number 5.
Alert 5 to 10 are connected matters, Lordship. But in item number 7, the service is not completed, Lordship.
Very well.
My Lord, I'm praying for dusty service as well.
Since service in one of the connected matters has not been completed, let the matters appear a further 3 weeks hence. Full stop. In addition to the department attempting service, comma, it will be open to the appellants in each case to effect service on the concerned respondents by any effective mode and file an affidavit of service. Give it a date.
Keep your
Item number 11.
Didn't know there were so many matters.
My Lord,
Yes.
I am appealing for the petitioner, my Lord.
Yes. What is the matter?
My Lord, on the last occasion, Your Lordship said, my Lord, this is, we are challenging the order by the CAT, my Lord.
Yes.
The transfer of the respondent has been interfered with by the learned CAT, my Lord, from Shillong to Tura, my Lord.
Yes.
My Lord, I am trying I'm trying to get the matter resolved, my lord. If losses grants me some time.
Very well. Since Dr. Modika represents that he is attempting to ensure that the issue involved is resolved, let the matter stand over for a fortnight.
My lord, one humble prayer is that the respondent here is not getting his salary since February last.
All dues of the respondent during the interregnum should be paid, whether or not the issues are resolved and whether or not and notwithstanding the pendency of this matter. Please pay him. Whether you transfer him or not, that's your option. But please pay him.
My lord.
Item number
I
12.
will ensure that.
Yes.
My lord, pursuant to the directions of this honorable court, my lord.
What is the matter about?
My lord,
It's an appeal. Yes.
My lord, this petitioner had approached this honorable court for regularization of her service. However, my lord, after hearing both the parties, my lord, the honorable court came to a conclusion, my lord, that she is entitled. The state should consider her appointment as far as the under the RCWA, my lord, regular casual worker scheme. My lord. Thereafter, my lord, what had happened, a certain time frame was given by the honorable court, my lord, in its directions. My lord, in the meantime, my lord, prior to the completion of the directions, the petitioner had approached this honorable court, my lord, challenging the order of the honorable single court below, my lord. Now, my lord, government has given a consideration thereafter, my lord, and the government has considered the post of the petitioner is given the status of RCW, my lord. If I'm allowed to.
Are you happy with that?
No, Your Lordship, may I please, Your Lordship. Your Lordships, because in this conferment of RCW status, Your Lordship, as per the RCW scheme, Your Lordship, she ought to have been conferred since the year 2003. Here, there's no mention with effect from which year.
Yes, it has to be that year.
The letter is enclosed. Lord, if I'm allowed to read, my lord.
Yes.
My lord, the letter is dated 19 September 2023, my lord, which is enclosed. With reference to the above, I am to inform you that the conferment on RCW status of Srimati Dil Kumar Chetri, part-time cleaner, as proposed by you by letter under reference.
State indicates that by letter of September 20, 2023, the appellant herein has been granted. What is RCW?
My lord, regular
Casual worker.
scheme.
Has been accorded regular casual worker brackets RCW status.
Yes, my lord. Yes.
Paragraph. However, the appellant claims that the appellant was entitled to regularization. Full stop. Further, without prejudice to the appellant's rights in the appeal, the appellant claims that at the very least, RCW status should have been granted to the appellant with effect from the year
2003.
2003. Full stop. The appellant submits that the recent letters of September 2003 does not throw any light on such aspect paragraph. The state should clarify whether the RCW status of the petitioner will date back to 2003. Full stop. In such event, if the state indicates as such, the petitioner's grievance may have been addressed. Full stop. Paragraph. Let the matter appear a fortnight hence for the state to indicate the position.
But one small aspect, my lord, if I'm allowed. My lord, in contention in our affidavit was it, my lord, that hers, as per my lord, our records, my lord, she would obtain the RCW status only in the year 2026, my lord. However, my lord, pursuant to the directions of this honorable court, we had considered that part. However, I'll get it clarified, my lord.
Get it clarified. Say it's not possible, give indication why it's not possible. She's climbing down from regularization without prejudice as of now, but effectively she's not pressing for regularization anymore. And then ultimately, if we see that she's entitled only from now, we don't have any special, affection for her.
My lord. Obliged.
Yes.
Item number 13.
What is this about, madam?
DSGI is director.
My lord, the service is not complete in this matter.
Very well, since, where are you?
My lord, I'm not, I have some health issues, my lord. I'm here, my lord.
Oh, you're here, all right. No, I thought that since today there's a lecture on ethics, you're running away. Yes.
But I have some L4 and F5 of some serious issues.
Yes. Since it is submitted on behalf of the applicants that service has not yet been completed, let the matter appear a fortnight hence. Service should be completed by such time, including by the applicants, and then affidavit of service filed.
My lord, sorry, my lord, my apologies. I'm appearing on behalf of respondent number 1, my lord, entering appearance today.
Very well. Just record respondent number 1.
Obliged.
Item number 2.
My lord, this matter was fixed today, my lord, on the.
Yes. What is the matter about?
My lord, Mr. Sen is, of course,
Mr.
Sir, this is with regard to appointed recruitment, my lord.
Yes. What do you want to do?
My lord, I was praying for little accommodation, my lord. On health ground, only, my lord. Maybe by Monday or Tuesday, I can do it.
Since the union seeks a short accommodation, let the matter appear a weekends. Next week.
Next week, okay.
I know.
My lord, if I can only make it clear, my lord, if it can be either on Tuesday or Wednesday, my lord. Either Tuesday or Wednesday.
18th, whatever is the date.
18th is my lord, Wednesday.
Item number 3.
I'm deeply.
May I please, Your Lordship? The instant appeal has been prepared against the impugn judgment.
Do you have a good case or a bad case?
My lord, in my humble submission, it is a very good case.
I don't want to decide any matter and disappoint any person at this stage. We'll adjourn it. Let someone else decide it later. It appears from your face that you have a very bad case before me.
My lord, my humble submission, my lord, it is a very good case.
If you say very good case, we take it up.
My lord, it is a very good case. Because the judgment, original judgment was upheld by the Honorable Supreme Court by a speaking order.
Let it be. Let it be. Let the appeal appear for hearing 3 weeks hence.
Can it be after 4 weeks, my lord?
4 weeks hence.